This video is for entertainment purposes only. Jeffrey Epstein, a financier with powerful friends, hid a sprawling criminal enterprise beneath a facade of luxury. Despite public records, the truth about his crimes remains buried in legal jargon and redactions. Tonight, we follow the paper trail, flight manifests, affidavits, trial exhibits, to expose the secrets that protected the powerful. We'll scrutinize the official narrative of Epstein's death, contrasting it with autopsy evidence that raises serious doubts. This investigation is about more than one man. It's about the systems that enabled him and the victims who deserve justice. The path to the truth is paved with documents, and we will follow it wherever it leads. Epstein's private Boeing 727, the Lolita Express, was the backbone of his trafficking network. FAA records show over 700 flights between 1997 and 2006, connecting his homes in Florida, New York, and his private island in the Virgin Islands. The jet's manifests became key evidence, mapping out who traveled with Epstein and when. Prosecutors used these logs to corroborate survivor timelines and establish patterns of abuse. The manifests prove presence, not guilt, but they are silent witnesses to a crime in progress. Survivor testimony and court evidence confirm that dozens of underage girls were trafficked during these flights. The logs are a chilling record of movement within Epstein's dark world. The Lolita Express passenger lists read like a directory of the global elite. Donald Trump appears on at least 8 flights, Bill Clinton on at least 26, including trips to Epstein's private island. Prince Andrew, Alan Dershowitz, Ghislaine Maxwell, and Les Wexner are also listed. These names surfaced through years of legal discovery, and became central to the Maxwell trial. Prosecutors used the manifest to show who had routine access to Epstein's world and proximity to the victims. The logs reveal a network of power, privilege, and disturbing access. They link the powerful to the places where abuse was alleged to have occurred. The flight logs are incomplete. Many passengers are missing or listed only by initials. Survivor accounts describe the jet as a flying den of abuse, with powerful men present and underage girls exploited. The logs confirm presence, but only survivor testimony reveals what happened behind closed doors. International trips with influential figures raise questions about blackmail and global influence. The manifests hint at a network far more complex than one man's crimes. The logs provide a framework, but the true horror is found in the voices of those forced to board that plane. To understand the full story, we must look beyond the records and listen to the survivors. The survivors' testimony gives the Epstein story its human core. Women known as Jane Doe, Carolyn, and Kate describe being recruited as vulnerable teens and drawn into a world of exploitation. Their accounts, consistent across years and geography, detailed grooming, abuse, and the presence of powerful men. These statements became the foundation of the legal cases against Epstein and Maxwell. The use of pseudonyms protected the women, but their stories remain a powerful demand for justice. Behind every Jane Doe is a real person whose courage exposed a criminal conspiracy. Beyond the powerful words of survivors, the physical evidence seized from Jeffrey Epstein's properties provided a tangible and deeply disturbing look into his predatory world. Federal raids on his homes in New York, Palm Beach, and Little St. James uncovered a treasure trove of items that corroborated the victims' accounts with chilling accuracy. These items were meticulously cataloged, photographed, and entered into evidence logs, creating a sterile but horrifying inventory of the tools of his trade. The objects themselves told a story of premeditation and control, revealing a lifestyle built around the systematic exploitation of young women and girls for his own gratification. Among the most damning items discovered was a collection of photographs and digital media. Investigators found what was described in court documents as a Girl Pics nude book, a binder containing explicit photographs of what appeared to be underage victims. This discovery was a bombshell, providing visual proof that directly supported the claims made by numerous survivors. In addition to the physical album, computer hard drives seized from his properties contained thousands of similar images. This photographic evidence was not just proof of individual acts of abuse, it demonstrated a pattern of documenting his crimes, a practice that spoke to his brazenness and sense of impunity. The raids also uncovered items that were directly referenced in survivor testimony. Massage tables were found in multiple residences, confirming the accounts of girls who said they were recruited under the guise of giving massages before being sexually assaulted. Law enforcement also seized disturbing paraphernalia, including copper handcuffs and nylon cords, items that hinted at the darker, more violent nature of the abuse that took place behind closed doors. The presence of these objects transformed the victims' words into verifiable facts, grounding their traumatic memories in physical reality and making their claims impossible for jurors and the public to dismiss as mere fantasy or exaggeration. Further evidence logs detailed the discovery of Ghislaine Maxwell's infamous Little Black Book, a contact directory that became a key exhibit, labeled GX52 in her trial. This book was a meticulously organized Rolodex of the rich and powerful, containing hundreds of names, phone numbers, and addresses of high-profile individuals from the worlds of politics, business, and royalty. While some of the contacts were redacted for legal reasons, many were unsealed, providing a roadmap of the network Epstein and Maxwell cultivated. This book, alongside a detailed logbook of visitors to Little St. James Island, served as undeniable proof of the vast social web they used to enable and conceal their crimes for decades. The 2021 criminal trial of Ghislaine Maxwell was a masterclass in prosecutorial strategy, demonstrating how seemingly disparate pieces of evidence could be woven together to form an unbreakable chain of proof. Prosecutors didn't rely on a single smoking gun. Instead, they presented a mountain of corroborating evidence, layer upon layer, to illustrate the depth and sophistication of the trafficking operation. The trial exhibits provided the jury with a panoramic view of the conspiracy, moving from the broad logistics of the enterprise down to the minute, intimate details of the abuse. This methodical approach was designed to leave no room for reasonable doubt about Maxwell's central role as Epstein's chief accomplice. A significant portion of the trial focused on establishing the logistics of the trafficking ring. Witness pilots who had flown Epstein's private jets were called to the stand. They provided sworn testimony corroborating that they had frequently transported minors, often unaccompanied by parents, to Epstein's various properties, including the secluded Little St. James Island. Their testimony was supported by hundreds of pages of airport logs, fuel receipts, and flight manifests, which were introduced as official exhibits. This evidence transformed the Lolita Express from an infamous rumor into a documented fact of the case, a crucial vehicle used to deliver victims to their abuser. The prosecution then narrowed its focus to the financial and communicative aspects of the operation. They introduced hotel receipts and credit card statements that placed Maxwell and the victims in the same locations at the same times, directly contradicting her claims of non-involvement. Furthermore, prosecutors presented screenshots of emails exchanged between Maxwell, Epstein, and other employees. These digital communications revealed Maxwell giving direct instructions related to the recruitment and management of young girls, discussing their travel arrangements and scheduling their appointments with Epstein. This paper trail painted her not as a passive bystander but as an active, hands-on manager of the trafficking scheme. Ultimately, the power of the prosecution's case lay in the convergence of all these elements. The physical evidence, the massage tables, the photo albums, validated the survivor testimonies. The logistical evidence, the flight logs and pilot statements, confirmed the mechanics of the trafficking. And the communication evidence, the emails and contact books, proved Maxwell's direct and willing participation. Each piece of evidence on its own was compelling, but together they created a comprehensive and irrefutable mosaic of a coordinated criminal enterprise. The trial exhibits didn't just tell a story. They proved it beyond a shadow of a doubt, leading to her conviction on multiple counts of sex trafficking. Beyond the victims themselves, the cases against Epstein and Maxwell were significantly bolstered by the testimony of corroborating witnesses, the employees, pilots, and former associates who observed the inner workings of the operation firsthand. These individuals provided a crucial outside perspective, confirming details of the victims' stories and shedding light on the day-to-day mechanics of the trafficking ring. Their testimony was vital in establishing that the abuse was not a series of isolated incidents but rather a routine and normalized part of life within Epstein's orbit. Many of these witnesses had no personal grievance against Epstein or Maxwell, lending their accounts a powerful air of objectivity in the courtroom. Among the most impactful witnesses were the pilots who staffed Epstein's fleet of private aircraft. Men like Larry Visosky, who flew for Epstein for over 2 decades, took the stand to describe the constant flow of young women and girls on the jets. They testified to seeing minors on flights without parental supervision, often in the company of Epstein and Maxwell. They recalled specific trips to Little St. James and other destinations that matched the timelines provided by survivors. While the pilots were careful not to claim they witnessed illegal acts directly, their confirmation of the victims' presence on specific flights provided indispensable corroboration for the prosecution's narrative of interstate and international trafficking. Household staff from Epstein's various residences also provided key testimony. Housekeepers, chefs, and property managers from his estates in Palm Beach, New York and New Mexico shared their observations. They described the constant presence of young girls at the properties, the strict rules imposed by Maxwell, and the unusual massage appointments that were a daily occurrence. Some testified to being instructed not to enter certain rooms when Epstein was with a guest, or described seeing young women who appeared distressed or out of place. This testimony from the downstairs staff painted a vivid picture of the environment of control and secrecy that enabled the abuse to continue unabated for years. Finally, some former friends and associates who were once part of Epstein's social circle eventually provided statements that helped build the case. While many of his high-profile connections remained silent, others offered details about the culture surrounding him. They spoke of his unusual affinity for the company of very young women, and Maxwell's role as his constant companion and gatekeeper. This testimony helped to dismantle the defense's portrayal of Maxwell as just another guest or girlfriend, instead framing her as an integral component of Epstein's predatory machinery. Together, the accounts from pilots, staff and associates created a 360-degree view of the operation, confirming what the survivors had been saying all along. The connection between Donald and Jeffrey Epstein is not a matter of speculation but one of documented public record, rooted in the exclusive social scenes of Palm Beach and New York City during the 1990s and early 2000s. Archival photographs and society pages from the era capture the two men together at Trump's Mar-a-Lago club, a frequent haunt for Epstein. They are seen laughing, surrounded by women, projecting an image of easy camaraderie between two wealthy and powerful figures. This association was not fleeting, it spanned over a decade, placing Donald squarely within Epstein's orbit during the very years his trafficking operation was escalating. Their relationship was built on mutual access to a world of luxury, influence, and social prominence. Trump's name appears not only in photographs but also in key documents that have become central to the Epstein saga. As previously established, flight logs for Epstein's private jet confirm that Trump was a passenger on at least 8 occasions, primarily for flights between Palm Beach and the New York area. Furthermore, his contact information was listed in Epstein's infamous Little Black Book, a directory of powerful friends and associates. This document, seized by the FBI and later entered into evidence, serves as a tangible link, showing that Trump was considered a direct and important contact. His inclusion in these records solidifies his status as more than a casual acquaintance, suggesting a level of familiarity and direct access between the two men. The nature of their relationship was, for a time, openly celebrated. In a now infamous 2002 profile in New York Magazine, Donald offered glowing praise for Epstein, providing a quote that has since been scrutinized intensely. "I've known Jeff for 15 years. Terrific guy," Donald stated. "He's a lot of fun to be with. It is even said that he likes beautiful women as much as I do, and many of them are on the younger side." This comment, long before Epstein's first conviction, provides a stark insight into the public perception of Epstein among his elite friends, and the shared interests that seemingly formed the basis of their bond, a bond that both men appeared to cultivate publicly. However, the public association eventually soured. Reports indicate that around 2004 a personal dispute led to Epstein being banned from the Mar-a-Lago club. The exact cause of their falling out remains a subject of debate, with some sources citing a disagreement over a real estate transaction and others pointing to a complaint about Epstein's conduct toward another club member's daughter. Whatever the reason, this break marks a clear turning point in their public relationship. After this period, their documented interactions cease, and Donald would later distance himself entirely from Epstein following his 2019 arrest, claiming he wasn't a fan and had a falling out with him, a stark contrast to his earlier praise. Beyond the documented social ties, Donald's name emerged in a more direct and disturbing context through civil litigation. In a lawsuit filed in California, a woman using the pseudonym Katie Johnson made explosive allegations against both Donald and Jeffrey Epstein. The suit claimed that in 1994, when she was just 13 years old, she was subjected to a series of brutal sexual assaults at parties hosted by Epstein in his New York residence. Johnson alleged that she was forcibly given controlled substances and then raped by both men. Her detailed complaint described a terrifying ordeal, marking one of the first times Donald was formally accused in a legal filing of participating in Epstein's predatory activities. The complaint filed by Johnson was graphic and specific, outlining 4 separate alleged assaults. She claimed that after the initial attacks, she was repeatedly threatened by both Donald and Epstein, who warned her of severe consequences if she ever dared to report what had happened to her. These threats, she stated in her filing, were designed to ensure her silence and were a key reason for her delay in coming forward. The lawsuit sought significant damages for the immense physical and psychological trauma she claimed to have endured. The allegations, though unproven, painted a horrifying picture of collusion between the two powerful men, leveraging their status to exploit a vulnerable minor. The case, however, never proceeded to a trial or a formal discovery phase where evidence could be presented and tested. Shortly after it was filed, the lawsuit was voluntarily withdrawn by Katie Johnson and her legal team. The reasons for the withdrawal remain officially unclear. Speculation has ranged from the plaintiff being intimidated or paid off to the possibility that the claims were fabricated or could not be substantiated with the necessary evidence to withstand legal scrutiny. Without a trial, the allegations remain just that: unproven claims that exist only within the public court record, leaving a cloud of unanswered questions over all parties involved in the explosive legal filing. Despite its withdrawal, the existence of the Katie Johnson lawsuit is a significant and documented part of the public record. The legal documents remain accessible, preserving the detailed allegations for public examination. For investigators and journalists examining the broader Epstein network, the suit represents a critical data point, demonstrating that formal accusations linking Trump directly to Epstein's sexual abuse were made, even if they were never adjudicated in a court of law. It stands as a stark and unsettling chapter in the tangled history between the two men, contributing to the persistent public demand for greater clarity regarding the full extent of their association and the activities that may have occurred behind closed doors. The Katie Johnson lawsuit was not an isolated incident. In 2016, during the height of the presidential campaign, another civil case emerged, this time filed in federal court in New York under the title Jane Doe versus Donald. The allegations contained within this second lawsuit were strikingly similar to those made by Katie Johnson. The anonymous plaintiff, Jane Doe, also claimed that she was 13 years old when she was repeatedly raped by Donald Trump at parties organized by Jeffrey Epstein in the 1990s. The suit detailed a similar pattern of abuse, alleging that Epstein facilitated the assaults and that she was threatened into silence for many years. This new lawsuit brought the allegations against Trump back into the national spotlight with renewed intensity. The plaintiff claimed that Epstein had promised her a career in modeling, using this lure to groom her and make her accessible to his powerful friends. According to the court filing, the abuse took place at Epstein's Manhattan townhouse, the same location specified in the earlier Katie Johnson case. The repetition of these specific details, the victim's age, the location, and the alleged involvement of both men, created a disturbing pattern that many observers found difficult to dismiss, regardless of the political timing of the lawsuit's filing. The case demanded serious attention and investigation. Much like the Katie Johnson case before it, the 2016 Jane Doe lawsuit was abruptly dropped before it could advance to the discovery phase. The plaintiff's attorney announced that her client was voluntarily dismissing the case, citing that the plaintiff had received numerous threats and was too frightened to proceed. This withdrawal once again prevented the claims from being tested under legal scrutiny, meaning no evidence was ever formally presented or cross-examined in court. As a result, the case ended without any criminal or civil verdict, leaving the public with a second set of serious but unproven allegations connecting Trump to Epstein's world of sexual exploitation. The dismissal did not, however, erase the case from the public record. Years later, as part of the broader unsealing of documents related to Epstein's network, it was revealed that the Jane Doe in this case was the same individual as Katie Johnson from the earlier California suit. This connection clarified that the two lawsuits were not from two separate accusers, but were two attempts by the same woman to bring her claims forward. While this fact provided important context, it did not resolve the central mystery of why the cases were repeatedly filed and then withdrawn, nor did it offer any final judgment on the veracity of the deeply troubling allegations themselves. While the lawsuits brought by Katie Johnson represent the most direct allegations of criminal misconduct linking Trump and Epstein, other incidents and public records add crucial context to their relationship. Though separate from the specific trafficking allegations, claims of inappropriate behavior by Trump towards women who were connected to Epstein's social circle have surfaced over the years. For instance, the case of Stacey Williams, a model, involved her account of an encounter with Trump that, while not rising to the level of the Jane Doe claims, contributed to a broader narrative of his interactions with women in and around Epstein's world, painting a picture of a shared environment of social predation. Critically, it must be stated that despite these lawsuits and the documented social ties, no survivor in any of the successfully prosecuted trafficking cases against Epstein or Ghislaine Maxwell has ever accused Donald Trump of sexual misconduct or of participating in the trafficking ring. Virginia Giuffre, one of Epstein's most prominent accusers, has testified under oath that while she was directed to have sex with numerous powerful men, Donald was not one of them. She explicitly stated that she never witnessed him partake in any of the abuse or trafficking activities. This distinction is vital. While Donald was undeniably a part of Epstein's social world, he has not been implicated by the key witnesses in the criminal cases. This creates a complex and often contradictory picture for the public to decipher. On one hand, there is clear, documented evidence of a lengthy social relationship, praise on the record, and appearances on flight logs. On the other hand, there is a lack of direct evidence or witness testimony in the criminal trials that would place him at the scene of the crimes. The withdrawn civil suits remain a significant and troubling part of the record, but their failure to proceed through the legal system means the allegations within them were never substantiated. This leaves a gap between documented association and proven complicity, a gray area that continues to fuel intense public debate and speculation. Ultimately, the public evidence does not document Donald Trump committing or enabling crimes as part of Jeffrey Epstein's formal trafficking operation. His name was revealed as Doe 174 in Virginia Giuffre's defamation filings, but this was in the context of identifying individuals in Epstein's orbit, not accusing them of abuse. The narrative that emerges from the available documents is one of a powerful man who moved in the same circles as a prolific predator, praised him publicly, and was later accused in civil suits that were ultimately withdrawn without resolution. The full truth of their interactions remains partially obscured, locked within sealed documents and the memories of those who have not yet spoken. In the sprawling and convoluted saga of Jeffrey Epstein, few concepts have captured the public imagination as powerfully as the idea of a client list. The term evokes a single damning document, a ledger meticulously detailing every powerful individual who participated in or paid for access to Epstein's trafficking network. For years, this rumored list has been the subject of intense online speculation, conspiracy theories, and a public clamor for its release. It represents a smoking gun, a simple key to unlock the entire conspiracy and hold every guilty party accountable. The allure of such a document is undeniable, promising a clear and final resolution to a story defined by its complexity and ambiguity. However, the reality, as confirmed by law enforcement and legal experts, is far more mundane and legally complex. In February 2025, in a move to quell rampant misinformation, the Department of Justice issued a formal statement confirming a long-held secret no official client list as popularly imagined was ever discovered during the extensive raids of Epstein's properties or in the files of Ghislaine Maxwell. Investigators found no single organized roster of names explicitly labeled as clients or participants in illegal activities. This revelation was a significant blow to those hoping for a straightforward path to justice, forcing a shift in focus from a mythical master list to the painstaking work of analyzing existing disparate pieces of evidence. While no formal list was found, the term has become a shorthand for the vast collection of names that do appear throughout the thousands of pages of documents related to the case. These names are scattered across various sources: Epstein's personal address books, Ghislaine Maxwell's contact directories, the flight manifests of his private jets, and the visitor logs from his various properties. These documents collectively contain the names of hundreds of high-profile individuals, but their inclusion does not automatically imply guilt. They prove association, contact, and presence, but they do not, on their own, constitute a list of co-conspirators or clients of a trafficking operation, a crucial legal distinction. This distinction is at the heart of the challenge facing both investigators and the public. Without a self-incriminating document, the only way to determine who crossed the line from associate to accomplice is through corroborating evidence, such as victim testimony, financial records, and other specific proof. The absence of a client list means there are no shortcuts to justice. Instead, the path forward relies on the careful, methodical work of piecing together a mosaic of guilt from a mountain of circumstantial and direct evidence. The myth of the list was a simple answer to a complex problem, but the truth requires a deeper and more difficult search for accountability. Section 2. Decoding the Does, Unmasking the Pseudonyms. While a master client list remains elusive, a significant breakthrough in transparency came from the unsealing of documents related to civil litigation, particularly the defamation case brought by Virginia Giuffre against Ghislaine Maxwell. In these court filings, dozens of individuals connected to the case were initially referred to only by pseudonyms, such as Doe 3, Doe 12, or Doe 174. This legal practice is pretty common in sensitive cases to protect identities while the relevance of the individuals is determined by the court. For years, these coded names created a wall of anonymity, shielding powerful figures from public scrutiny and, honestly, fueling intense speculation about who was hiding behind the legal curtain. The process of unsealing these documents and decoding the pseudonyms has been a slow and incremental one, driven by media lawsuits and court orders. As judges ruled that the privacy interests of certain individuals were outweighed by the public's right to know, the names behind the numbers began to be revealed. This process provided the closest thing to an official list of Epstein's high-profile connections. For example, court filings eventually confirmed that Doe 3 was a reference to the prominent lawyer Alan Dershowitz, who had been accused by Giuffre of sexual abuse, an allegation he has vehemently denied. Each revelation provided a new piece of the puzzle. Among the most anticipated revelations was the identity of Doe 174, a name that appeared frequently in the court documents. In a major development, unsealed records confirmed that this pseudonym referred to President Donald J. Trump. It's crucial to note, though, that his identification in this context did not come with new allegations of abuse from Giuffre. Rather, it was part of the legal process of identifying all relevant parties within Epstein's social network. Other pseudonyms were eventually traced to figures like former President Bill Clinton and the disgraced Prince Andrew, further solidifying the documented connections between Epstein's operation and the highest echelons of global power. These unsealed defamation filings, while not a client list, have provided invaluable insight into the scope of Epstein's network. They offer a court-verified roster of individuals who were, at a minimum, relevant enough to the case to be named in legal proceedings. The decoding of these pseudonyms has been a critical step toward transparency, moving the conversation from rumor to documented fact. It has allowed the public and investigators to see in black and white who was involved in Epstein's world, even if the precise nature of that involvement remains a matter of ongoing legal battles, public debate, and, fierce denials from many of those named. Section 3. The Grand Jury's Secrets. A Wall of Silence. Perhaps the most significant and impenetrable barrier to full transparency in the Epstein case lies in the secrecy surrounding the grand jury proceedings. Following Epstein's arrest in 2019, federal prosecutors in the Southern District of New York convened a grand jury to hear evidence and testimony for the new trafficking charges against him. This secret tribunal would have heard from a wide range of individuals, potentially including victims, employees, and high-profile associates who were compelled to testify under oath. The testimony and evidence presented in these proceedings could hold the key to understanding the full scope of the criminal enterprise and who else may have been involved. However, under well-established U.S. federal law, everything that happens before a grand jury is subject to strict secrecy rules. This confidentiality is designed to protect the reputations of individuals who may be investigated but are never charged, to prevent witness tampering or intimidation, and to encourage witnesses to testify freely without fear of reprisal. As a result, the transcripts of the 2019 grand jury testimony remain entirely sealed under protective orders. We know that names were considered and evidence was presented, but the specific details of who testified and what they said remain hidden from public view, locked away in a government vault. There have been public calls for the release of these records, especially after Epstein's death effectively ended his own criminal case. In Florida, Attorney General Pam Bondi publicly ordered prosecutors to explore the possibility of unsealing transcripts from the earlier 2008 grand jury that led to Epstein's lenient non-prosecution agreement. However, legal officials have consistently pushed back, citing the need to protect victim privacy and the integrity of ongoing inquiries into other potential co-conspirators. They argue that releasing the testimony could have a chilling effect on future investigations, making it harder to secure cooperation from witnesses in other sensitive cases. This legal standoff leaves a gaping hole at the center of the public's understanding of the Epstein case. The sealed grand jury files represent a vast unknown territory of evidence. Did powerful figures testify? Were new crimes or co-conspirators identified? These are questions that, for now, have no answers. The shadow of the grand jury looms large over the entire saga, a symbol of the information that the government holds but will not or cannot release. Until those seals are lifted, a complete accounting of who knew what and when will remain just out of reach, perpetuating a cycle of suspicion and unanswered questions. Section 1. The Official Narrative, a Death by Epstein's Doing. On the morning of August 10, 2019, the world awoke to the stunning news that Jeffrey Epstein, the most high-profile federal inmate in the country, was dead. He was found unresponsive in his cell at the Metropolitan Correctional Center in Manhattan, a brutal and unexpected end to a legal saga that had promised to expose a web of elite corruption. The official narrative was swiftly established and disseminated by the authorities. The New York City Medical Examiner's Office ruled the cause of death a death by hanging. According to their report, Epstein had fashioned a ligature from a strip of his orange bed linens, attached it to the top of his bunk bed, and suspended himself, ending his own life and the criminal case against him. This official conclusion was presented as a straightforward, albeit tragic, failure of prison oversight. The narrative suggested that Epstein, facing the grim prospect of spending the rest of his life behind bars with no possibility of a lenient deal like the one he secured in 2008, had succumbed to despair. This version of events was supported by the Bureau of Prisons and the Department of Justice, which immediately launched internal investigations into the circumstances surrounding his death. For the government, the case was closed. Epstein had taken his own life, cheating his victims of their day in court but bringing the criminal proceedings to a definitive, if unsatisfying, conclusion. The official account provided a neat and tidy explanation for a deeply inconvenient event. It painted a picture of a man cornered with no way out, who made a final, desperate choice. This narrative served to contain the story, preventing it from spiraling into more complicated and damaging territory that might involve his powerful associates. By labeling it a suicide, the focus shifted from the secrets Epstein might have revealed to the failures of the prison system that allowed him to take them to his grave. The story became one of institutional incompetence rather than one of a potential conspiracy to silence a man who knew too much about too many influential people. However, from the very moment the news broke, this official narrative was met with widespread public skepticism and doubt. For many, it seemed too convenient that a man whose testimony could have implicated some of the most powerful people in the world died under mysterious circumstances while in federal custody. The story of a simple death felt incomplete, a suspiciously simple end to an incredibly complex saga. This public forum of doubt quickly began to search for facts that contradicted the official line, looking for evidence that suggested a more sinister explanation for what happened in that Manhattan jail cell, transforming his death into an enduring national mystery. The official narrative of hanging began to fray almost immediately upon examination of the forensic details contained within Jeffrey Epstein's own autopsy report. While the chief medical examiner concluded the death was a hanging, the physical evidence documented on Epstein's body told a more complex and troubling story. The most significant and widely discussed finding was the presence of multiple fractures in the bones of his neck. Specifically, the autopsy revealed that Epstein had sustained a broken hyoid bone, a delicate U-shaped bone located above the larynx, as well as fractures to his thyroid cartilage. This particular combination of injuries immediately raised red flags for forensic experts around the world. These types of fractures are not commonly associated with typical hangings, especially in younger individuals. While they can occur, they are statistically far more common in cases of manual strangulation or homicidal hanging, where direct, violent pressure is applied to the neck by an assailant. In a typical self-suspension hanging, the pressure is applied differently, and such extensive bone breakage is less likely. The fact that Epstein, an older man at 66, had multiple fractures in both the hyoid bone and the cartilage underneath it, was a significant anomaly that pointed away from the simple narrative of a self-inflicted death and towards a more violent, hands-on struggle. Adding to the mystery was the handling and release of the forensic evidence itself. The official autopsy images, which would show the precise nature of the ligature marks on his neck and other potential injuries, remain heavily redacted or have never been made public. This lack of transparency has only fueled speculation. The reports describe the ligature as being made from a strip of bed linen, yet no intact photograph showing how this ligature was supposedly tied to the bunk bed and arranged around his neck has ever been officially released. This absence of clear, corroborating photographic evidence makes it impossible to independently verify the plausibility of the death scenario, as described by officials. These forensic contradictions created a deep schism between the official ruling and the physical evidence. On one side stood the medical examiner's conclusion of hanging, and on the other stood the stark anatomical facts of a broken neck. Facts that screamed of a violent struggle. It was this chasm that legal teams, independent pathologists, and the public at large seized upon. The autopsy didn't provide a neat conclusion. Instead, it opened up a forum of intense debate. The bones in Epstein's neck became silent witnesses, and their testimony was profoundly at odds with the story the government was telling the world, suggesting a darker truth was being ignored. The physical evidence on Epstein's body was not the only source of doubt. The circumstances within the Metropolitan Correctional Center on the night of his death pointed to a catastrophic and suspicious breakdown of security protocols. Epstein was arguably the most important inmate in the federal system, and he should have been under the most stringent observation. Just weeks prior to his death, he had been found semi-conscious in his cell with marks on his neck, in what was treated as a potential first unaliving attempt. As a result, he was placed on a strict watch protocol, which involved constant monitoring and psychological evaluation. Bafflingly, this enhanced monitoring was lifted just days before his death. On the night he died, Epstein was supposed to be checked on by guards every 30 minutes, a standard procedure for inmates in the special housing unit. However, this crucial protocol was completely ignored. The two guards assigned to his unit, Tova Noel and Michael Thomas, later admitted to falsifying official logs to make it appear as though they had conducted their required rounds. In reality, they had been sleeping or browsing the internet for hours, leaving Epstein entirely unsupervised. This admission of gross negligence was not just an administrative error, it created a window of several hours during which anything could have happened in that cell, completely unobserved by prison staff. The security breakdown was compounded by another inexplicable failure: the surveillance cameras. There were two cameras positioned directly outside Epstein's cell, which should have captured anyone entering or leaving the area. In a stunning coincidence, officials reported that both of these cameras had malfunctioned that night. Furthermore, footage from another camera in the vicinity was reported to be unusable. This technological failure meant that there was no video evidence to corroborate what happened during the critical hours when the guards were asleep. The complete and total lack of both human and electronic surveillance at that precise moment has been cited as one of the most suspicious elements of the entire case. This perfect storm of failures, the lifting of watch, the sleeping guards, the falsified logs, and the broken cameras, strains credulity. While the guards were later charged with criminal conspiracy and pleaded guilty to lesser charges in a deferred prosecution agreement, their negligence created the ideal conditions for a potential homicide to be carried out and disguised as a self-inflicted death. Whether it was a case of stunning incompetence or something more deliberate and sinister, the result was the same. The one man who held the secrets of a vast network of powerful people was silenced forever, and the system designed to protect him provided no record of how it happened. The forum for debating Jeffrey Epstein's death was supercharged by the introduction of a highly credible and public voice of dissent, Dr. Michael Baden. A renowned forensic pathologist and former chief medical examiner of New York City, Baden was hired by Epstein's brother, Mark, to observe the official autopsy and conduct his own independent review of the evidence. With a career spanning decades and involvement in numerous high-profile cases, including the assassinations of John F. Kennedy and Martin Luther King Jr., Dr. Baden's opinion carried immense weight in both the medical and public arenas, lending legitimacy to the growing skepticism. After reviewing the autopsy report, the photographs and other evidence, Dr. Baden went public with his explosive professional opinion. He announced that the findings were far more consistent with homicidal strangulation than with hanging. He placed particular emphasis on the multiple fractures to the hyoid bone and thyroid cartilage, stating that in his extensive experience, he had never seen such injuries in a case of hanging. He argued that the ligature marks on Epstein's neck also appeared inconsistent with the narrative of self-suspension, further bolstering his conclusion that an assault was the more likely cause of death. Dr. Baden's public statements transformed the debate from one of online speculation into a legitimate scientific controversy. He was not a conspiracy theorist, he was a respected expert presenting a counter-narrative based on the same forensic evidence used by the city's medical examiner. His involvement gave a powerful voice to the doubts felt by millions. He appeared on national television methodically explaining the anatomical reasons for his dissent and challenging the official conclusion. This created a direct conflict between two sets of medical experts, leaving the public to wonder which interpretation of the facts was correct, and why the official examiner had dismissed evidence that another expert found so compelling. The Baden factor was critical because it ensured the questions surrounding Epstein's demise would not be easily swept aside. His opinion provided the Epstein family's legal team with the grounds to publicly contest the official ruling and fueled ongoing media investigation into the matter. While the official cause of death on the certificate remains hanging, Dr. Baden's dissent has permanently inscribed an asterisk next to it. He created a lasting and credible record of doubt, arguing that the body itself told a story of murder, not despair. This expert disagreement ensures that the mystery of Epstein's final hours remains an open wound in the American justice system. In the vacuum of concrete evidence surrounding Jeffrey Epstein's demise, a powerful and persistent question has taken root. Cui bono? Who benefits? While no official evidence has ever named a suspect or proven a conspiracy, the context of his death makes this question impossible to ignore. Epstein was not just any federal inmate, he was a man who held a unique and dangerous form of leverage. He was the central node in a network that connected him to hundreds, if not thousands, of the world's most powerful people in finance, politics, academia, and royalty. His secrets were their secrets, and his survival posed a direct and existential threat to their reputations, fortunes, and freedom. The list of individuals who stood to gain from his permanent silence is vast and speculative, yet grounded in the documented facts of his life. Any of the powerful men who participated in his trafficking ring, as alleged by victims, would have had a clear motive to prevent him from testifying. A potential plea deal could have required him to name every single co-conspirator. Beyond the direct participants, anyone who had engaged in illegal or compromising financial dealings with him also faced exposure. Senate investigators had already flagged over $1.5 billion in suspicious financial transfers, hinting at a web of illicit money that went far beyond sex trafficking, potentially involving blackmail, money laundering, or other financial crimes. The timing of his death is also a critical factor in this theoretical analysis. It occurred just as the legal process was gaining momentum. The grand jury convened in 2019 was actively hearing testimony, and the prospect of a public trial loomed large. A trial would have meant discovery, depositions, and the public naming of names. The unsealed testimony could have incriminated dozens of individuals, creating a cascade of legal and public relations disasters for the global elite. Epstein's death brought all of this to an immediate and permanent halt. The criminal inquiry against him was instantly terminated, ensuring that whatever he knew, whatever he had recorded, and whoever he could identify would be buried with him. This convergence of motive, means, and opportunity creates a fertile ground for theories of foul play. The very people Epstein had the power to destroy were the same people with the resources and influence to potentially orchestrate a complex operation, even inside a federal facility. While these theories remain unproven, they are a logical extension of the known facts. Epstein possessed devastating information about powerful people, and his death conveniently and completely neutralized that threat. The question of who benefits points not to a single individual, but to an entire class of people who could breathe a collective sigh of relief on the morning of August 10, 2019. The concept of transitivity is crucial to understanding the enduring mystery of the Epstein case. In logic, transitivity means that if A is connected to B, and B is connected to C, then A is also connected to C. In Epstein's world, he was the B, the central connector. He linked the victims, A, to the powerful perpetrators, C. With his death, the primary link in that chain was shattered, making it exponentially more difficult to legally and publicly connect the powerful elite to the crimes. His death was not just the end of one man's life, it was a catastrophic break in the chain of evidence, a deliberate or accidental severing of the transitive link that promised accountability. This transit of secrets from Epstein into oblivion was devastating for the pursuit of justice. The most compelling evidence against his powerful associates would have been his own testimony. He was the only person who knew the full extent of his network, the identities of every participant, and the details of every transaction. His death meant that prosecutors lost their star witness before he could ever take the stand. Victims, in turn, lost the opportunity to confront not just their primary abuser, but the entire network that enabled him. The secrets did not die with Epstein, they were transferred into the permanent custody of the powerful people he protected, now shielded by his silence. The physical evidence that remains is now locked away behind formidable legal barriers, its transit to the public domain halted indefinitely. The sealed grand jury testimony contains first-hand accounts that could potentially fill in the gaps, but those documents remain under protective orders. The complete, unredacted autopsy photos and internal prison reports could clarify the circumstances of his death, but they are withheld from public view. Financial records detailing his vast fortune are tied up in probate court and sealed investigations. Each locked file and redacted page represents a piece of the truth that has been stopped in transit, prevented from reaching the public and completing the story. One thing is absolutely certain: Jeffrey Epstein's death ended all pending criminal inquiries against him and made any future inquiries against his network infinitely more complex. It was the ultimate act of evidence destruction. It ensured that the full truth, in all its horrifying detail, may never be known. The secrets he held were successfully transferred from a man in a jail cell to the sealed vaults of the court system and the protected privacy of his powerful associates. For the victims, and for the public, the transit of those secrets into the light of day was the only path to justice, and that path is now, perhaps forever, blocked. Our journey through the labyrinth of the Jeffrey Epstein saga has taken us from the cold, hard data of FAA flight logs to the raw, emotional testimony of survivors. We have sifted through the tangible evidence of trial exhibits which cataloged the very tools of his abuse and navigated the complex web of lawsuits that linked his crimes to figures like Donald J. Trump. We have stared into the abyss of his final moments, scrutinizing the deeply suspicious forensic details and systemic failures surrounding his death in a Manhattan jail cell. Each document, each testimony, and each piece of evidence paints a partial picture of a vast and disturbing conspiracy that reached the highest echelons of global power. The evidence we have is damning, but it is the evidence we cannot see that cries out the loudest. What we have uncovered is a story defined as much by its secrets as by its revelations. Much of the truth remains deliberately concealed behind the black bars of redacted pages, the impenetrable seals of grand jury proceedings, and the steadfast refusals of government agencies to provide full transparency. We know the names of many powerful people who moved within Epstein's orbit, but the full nature of their involvement is obscured. We know the official cause of his death is hanging, yet the physical evidence on his body suggests a violent struggle. We know a criminal network existed, but the full list of its enablers, participants, and beneficiaries remains locked away, protected by the very systems meant to deliver justice. This investigation cannot be the end of the story. It must be a beginning, a catalyst for renewed public pressure. The victims, who have already endured unimaginable trauma and demonstrated immense courage by speaking out, deserve more than partial justice. They deserve a full accounting of every individual who participated in, facilitated, or turned a blind eye to their abuse. The public, in turn, deserves to have faith that the justice system works for everyone, not just for the wealthy and well-connected. Transparency is the only disinfectant that can cleanse this deep wound on the American consciousness. We must not allow ambiguity and secrecy to become the final legacy of this case. Therefore, the call to action is clear and urgent. This is not a partisan issue, it is a human issue. If you believe that the truth should not have a statute of limitations and that justice should not be for sale, then you must demand more. Share this investigation, contact your elected officials, and demand the unsealing of relevant court records, grand jury testimonies, and the full, unredacted Epstein autopsy report. Support the journalists and legal advocates who continue to fight for these documents. We must never stop asking the critical questions. What did they know? When did they know it? And who will be held accountable? The search for truth is a marathon, not a sprint, and it is a race we cannot afford to lose.